Good morning. We're here for oral argument on Center for Arizona et al. I know it's policy et al. Versus Arizona Secretary of State et al. It's our number CV-24-0295. A couple of things before we get started. First, Justice Mary Elena Cruz is recused in this matter, so joining us today is retired Justice Rebecca Birch. Thank you, Justice Birch, for filling in. It's always good to have you here. Other than that, I know we have all experienced counsel. You all know how much time you have. It's at the podium. Mr. Gould, you will have to keep your time for yourself for rebuttal if you would like any. So please begin.
For the record, my name is Andrew Gould. I represent the petitioners, Free Enterprise Club, and Center for Arizona Policy. In terms of the central issues in this case, I would point to two. One is the retaliation issue, and the other is the lack of narrow tailoring. With respect to retaliation, Buckley, Bonta, Citizens United, they've laid out a very broad standard of any type of harassment or reprisals in response for speech. And I think the important thing in terms of the orientation here is the chilling of speech. There's been some argument that you have to show a specific donor was threatened because of a specific disclosure. Nowhere in Buckley, nowhere in Citizens United, nowhere in Bonta is that standard made.
So are you going with your as-applied? Are you going with the as-applied challenge first? I just want to know where you're going with
Yes.
your arguments, so I don't misdirect you.
Yes. Did you have a question, Your Honor?
Yeah. So you as-applied. Well, and I do have a question about the as-applied challenge because it seems as if, and there are certainly circumstances in which you would have a chilling of speech if truly donors are being harassed, or certainly a reasonable probability of being harassed, threatened, that type of thing, and in certain instances. But my understanding of your as-applied challenge is that it is seeking as applied to these entities for any election, for any circumstance. So even if there is a tax initiative on the ballot or any particular candidate that CAP or the Free Enterprise folks contribute to, that they are exempted then because this act is as applied to them in every instance would be unconstitutional. Is that what you're arguing?
That's what Buckley says. Buckley talks about a reasonable probability that they will be subject to past or present harassment of members due to their associational ties or against the organization itself. That's the standard. So it's harassment directed at members or the organization, past or present. So of course, when you make threats or you harass a certain member on any election issue, it's going to chill the speech of every other member, every other donor. They're not going to want to give a check if somebody throws a Molotov cocktail through another member's window. It doesn't have to be a threat directly at the individual, and that's not the standard.
Well, no, and I understand that. It's a little bit different than my question. My question is, are you saying that this act, as applied to your clients in every instance, for every initiative, every candidate, every potential recall in the future forever, it would be unconstitutional as to them?
Well, I'm not sure how to answer that question, Your Honor. I think Prop 211 by its terms is categorically chilling on free speech. And so it's a facial challenge in that regard that any application of this, any donor who's subject to the act is subject to retaliation. So, I mean, it's a categorical prohibition on it. In terms of the record, I mean, it's past retaliation.
So this is my issue with the as-applied part of it, not the facially unconstitutional, putting that aside because you started with as-applied, that if you had a specific initiative, maybe one, since I know CAP does a lot with family planning and abortion and those kinds of things, and the initiative had to deal with the abortion initiative, for example, then sure, you can go and say, look, Judge, we've had these harassment, we've had these threats, we've had all these things because it's such a divisive issue and it really does chill donors wanting to come and contribute to be part of this. But if it's a situation where it's a tax issue, people aren't also riled up about that. And so that's what is difficult for me to just say for every possible initiative that might come up, this would be unconstitutional as applied to them. And so that's why I'm asking you, is that what you're arguing?
I am. I think the standard that you're looking at, Your Honor, is impossible. What donors give to today in CAP may be innocent enough, but 10 years from now could deal with retaliation. So you're asking them to predict the future. I would put it in this context. In NAACP versus Alabama, the disclosure of those members subject them to harassment. They didn't need to predict in the future whether things would change in Alabama and there might be a different environment. It was a retaliatory environment that chilled their speech at that time. And so no case requires any donor to forecast, well, you might have issues that you're not facing retaliation against. It's retaliation against the organization for the views that it espouses. Now, you can look at what CAP promotes. It's pro-life, it's pro-family, all those issues. So, I mean, it would have to be within the umbrella of what that C3 does.
But if tomorrow or next year CAP wanted to start branching out and, okay, beyond just pro-life and those kinds of things, that they wanted to go into zoning issues or other things, anything really. You're kind of, it sounds like you're asking for an exemption from this act for them no matter what. And I guess that's why I'm asking it. Is that what you're arguing?
I am. I mean, that's what Buckley says. That's what Bonta says. That's what Citizens United says.
Just to be, I think I read in all of this voluminous documents that we received that CAP has a PAC and it reports to the Secretary of State the identities of its donors to that.
Oh, no, no.
Is that not?
That is not true. That's a separate PAC, a separate entity.
But no association between the two?
Well, it's a PAC that is for CAP, but that's different from the 501c3. That is a very misleading statement. That entity's not before the court. There isn't one shred of evidence that a single donor to CAP or $1 from CAP went into that PAC.
Well, both
PACs have to disclose their donors under federal law. C3s don't. They're not political committees.
Both the trial court and the Court of Appeals cited it. That's why that fact, and as evidence that it wasn't sufficient to show the harassment just for everything that has been done for the as-applied charge. That's why I was asking about it.
Right. It's a separate entity. And I think if you look at Bonta says, even if it's not, or even if there's past disclosures, every time you're required by the government to disclose your name, that's a chilling effect.
Counsel, would there be an expectation? Go ahead.
And I want to couch it with a couple of points here too. Is that we're here on a 12b6 motion, so we're to assume the truth of all well-pled facts and allegations. And within the record, then there are declarations identifying particular threats that have been made against members of CAP. We have declarations from individuals who have donated to CAP and say that they fear reprisals, et cetera. So taking that as true, and I want to underscore my understanding of your argument, that at least with respect to those issues that CAP is on record of supporting, pro-life, pro-family, pro-marriage, those types of issues, is your argument that with respect to any issue advocacy CAP would engage in, those defined areas, that we should rule as the Voters' Right to Know Act is applied to them for those categories, that it is unconstitutional? And then I have another question to ask.
Yes, because otherwise you can't establish a relationship between the threats and the harassment and the organization. And so, of course, it has to be related to what the organization stands for. If it were a random act where somebody firebombed their offices and they didn't even know that it was CAP's office, then that wouldn't be retaliation against the organization or the membership for what they stood for.
But I get the broad statement that you're making about retaliation and reprisals. I understand that, and I'm taking that as true based on being at the 12b6 motion stage and what we have in declarations and affidavits. So I understand that part. But what I want to make sure I understand is that your as-applied challenge is saying that CAP or Free Enterprise Club, this is what we engage in. So whenever we engage in these activities, the Voters' Right to Know Act is unconstitutional if the Clean Elections Commission or anybody else were seeking disclosures under that act when we engage in these activities in these specific areas.
Well, somewhat, Your Honor. I mean, it's what the organization stands for. It's a pro-choice organization. It's a pro-family organization. If people harass and threaten that organization or its members because of the views that they promote about the positions it takes, then that is retaliation for their speech.
Okay.
It has to be tied to speech.
So
Yes, but it's sort of a practical connection. If it's not tied to their speech, then there wouldn't be any basis for chilling of it, and there wouldn't be any basis for an as-applied challenge.
But just to be clear, and I know, because I just want to make sure that from what you just said to Justice Montgomery, I thought it was slightly inconsistent with what I thought I heard from you, that when I asked, would this apply for no matter what CAP did, even if it expanded beyond and went into tax and zoning and everything, and I thought you said yes, it would. Yeah. And then you said that was what you're arguing. I heard something different.
Your Honor, your question confused me. That's my fault. I'm sorry. Mm-hmm. I don't mean that in a bad way. I was confused by it. I think that you have to tie it to speech. What is the speech of the organization? So if it's not connected to chilling of free speech, then there wouldn't be any retaliation, there wouldn't be any exemption.
But if they're making a donation to CAP, who then makes a donation to something about an initiative with zoning, is that not tied to speech?
Well, that's for an as-applied challenge, I guess. I'm not sure how to answer that question.
That's what I'm struggling with too, is how to fix the universe in which we're supposed to analyze these issues. I see we've got several different constitutional provisions that we're having to take a look at. There's Article 7, Section 16, Article 7, Section 12. There's Article 2, Section 6, Article 2, Section 8. And oh, by the way, if we're talking about initiatives and ballot propositions and advocacy in that realm, we're also talking about Article 4, Part 1, Section 1, which I didn't see anybody address. So what I'm trying to do is figure out, in order to achieve a workable set of facts and a framework for analysis, how big is the universe we have to look at this issue within? Or can we say, well, you know what? We know that at least when the Constitution was adopted, there was a concern about campaign finance with respect to candidates, candidate committees, and candidate elections. We know there was a concern about the purity of elections. And at least with respect to the original public meaning of to speak in 1912, it did not include expressive conduct. That doesn't come until decades later when the federal Supreme Court wants to interpret the First Amendment to incorporate expressive conduct. And then Buckley, that you mentioned, Citizens United, that political speech, campaign contributions and campaign spending is political speech which is protected. I say all that to say this. When we look at the entire Voters' Right to Know Act and the argument that, well, as applied to CAP, whenever CAP engages in issue advocacy in the areas that it is declared the organization stands for, whenever we engage in those activities, we're exempt from the Voters' Right to Know Act. I know there's a lot of lead-in, but I'm trying to convey to you the difficulty I'm having getting my arms around this.
I'm sorry, Your Honor, which part of that question did you want me to address?
I'd like you to address the last part of it.
And that is,
the last part of
what's the standard for as-applied retaliation?
Well, no, because I think we've got that.
Okay.
That's pretty clear. But again, what I'm trying to figure out is CAP arguing, and Free Enterprise Club, are you arguing that whenever we engage in our declared scope of activities, because of, and again, we're at the 12B6 stage, because of what our organization's members and donors have said, you can't apply the disclosure requirements to us when we engage in these types of activities?
I wouldn't read it that way, Your Honor. I would say when an organization engages in expressive conduct, when it speaks for its members, and there is retaliation against that organization and its members for that speech, that's an as-applied challenge because it chills free speech, and they get an exception from that disclosure law. That's what the law says.
Okay,
I don't know
so-
what else to add to that.
And I apologize for interrupting you, but I want to make sure we take valuable use of the time that we have. If we look at 16973F.
What statute?
16973F, that's where, if you can get a court order that would, it can exempt you from having to disclose donor information. I'm butchering the paraphrase, but that's where it is. Or you get the Clean Elections Commission to find that there's been a threat of physical harm. Why is that not workable when an actual issue arises within a specific ballot proposition or circumstance?
Are you talking about 16974 or 16977?
No,
One is a commission action, other is a private cause of action.
No, 973F, which provides for the ability for a donor to make a showing in order to avoid disclosing their information.
And your question is, Your Honor?
Why isn't that good enough? If the statute specifically contemplates the ability for a donor to make a necessary showing to preclude having to disclose their information, why isn't that good enough?
Well, because the statute's unconstitutional as applied. Why would they have to go before a commission to show it's unconstitutional?
I get it. I don't want to go back around and around. So let me just ask the standalone question. 16973F permits a donor to make an appropriate showing to be able to withhold their information. They can go before a court. I don't know what else that means. That's what it says. But they go before a court. If there is the ability for any individual donor to have their information withheld, why isn't that good enough to address concerns about chilling speech?
Because your speech is chilled. The very idea that you might face retaliation chills your speech. You have to have breathing space for First Amendment rights. And going before a commission is certainly one way to do it, but in the meantime, people will self-censor. They won't contribute because they're afraid of retaliation, because they've seen what happens to other people that contribute, or they've experienced it themselves.
Let me restate what you said to make sure I understand it then, and I apologize for interrupting you. But so your position would be that even though that provision is provided, even though that provision exists, in the interim, unless and until somebody actually gets a decision that they can withhold their information, your position is, well, it's still chilled, and they may very well self-censor because they're not sure, unless and until that happens, that they'll actually be able to prevent disclosure.
Yes.
Okay, thank you.
Following on that, isn't that all a way of saying that this really is a facial challenge and not an as-applied challenge?
It is a facial challenge because when you look at the categories of what have to be disclosed, the informational interest is weak and it's not narrowly tailored. And as Bonta said, if any donor that faces a disclosure law is subject to a regulation that doesn't have a strong informational interest and isn't narrowly tailored, all of those donors have their constitutional rights chilled. That's exactly what Bonta says. You don't have to show a number of people. Any donor over $2,500 who donates, that donation is subject to disclosure. And exacting scrutiny, it fails exacting scrutiny because it's not narrowly tailored. And there's a number of ways, but it's not narrowly tailored.
Why doesn't the opt-out notice cure that defect?
There's a number of problems with the opt-out notice. First of all, it doesn't apply to top 3 donors. They don't get it. Second of all, original donors don't get it. They give through intermediaries. They don't get it. And third, this is something that Buckley talked about. The way the campaign media spending definition is drafted, it is so broad, it sweeps in issue advocacy as anything with the campaign media spending. For example, if someone gives to CAP, and they want to give to CAP on abortion, pro-choice, and they give that money for research on abortion and statutes and analysis of legislation, and staff at CAP perform that work. And they get some polling, they get some studies on the trauma that women suffer from abortion, and they give money just to that. They say, I don't want to give to campaign media spending. How can you say that that expenditure at some point isn't in preparation for the campaign media spending, the campaign ads, that use that research, that use that polling, that use those employees to perform that. And that's something that Buckley talks about, where it says, you know, when you get into the area of independent expenditures, there's a tremendous overlap between issue advocacy and political advocacy. It's become a nightmare for these organizations to try to separate the two. And so what happens under the Act is you're at risk of exposing and disclosing donors who never gave to support the Act. That's why Buckley talks about earmarking, so that those people whose names are disclosed, at least they said, I want to give to the campaign spending. But original donors, original contributors, they never get a notice, they never know. Top 3 donors don't. Even people who give for issue advocacy, they don't know if that money that they gave is ultimately going to be used in preparation for or in conjunction with some campaign meeting spending.
Does the timeline of the opt-out notices going out, and then there's a 21-day waiting period, I believe, in the statute. So there's a timeline and a series of events that occurs here. Could that result in a situation of preventing a covered person from speaking during a campaign season?
And before you answer, I know you see that your time has expired, but you know, these are important issues, obviously, and so we have a lot of questions. So could you add 10 minutes to each side for me? And please go ahead.
I'm sorry. So the 20, yes, of course it's a chilling. Anytime when you get close to an election, we have to wait and you're not certain whether your name is disclosed, it's chilling your speech. I.e. speak directly on issues. They're not like contributions to campaigns. Campaign money goes to a lot of different things. Money that goes to IE goes directly to campaign speech. So when you hold up these donations, when you put in doubt whether somebody's disclosed or not, and you do it close to these elections, you're effectively denying that speech. And then you have the private cause of action, Justice, in 16977, where someone can file a complaint. And if they don't like the commission's decision, they can file a private cause of action against you. And that private cause of action can tie it up. And again, even if they get a successful ruling, or even if they put something in front of the commission, they want an opt-out, all that delay chills speech at a critical time in the election process.
Justice Gould. Mr. Gould. Justice Montgomery asked a question that I want to ask you directly, and then a follow-up to that. Do you agree that at the time this provision was adopted, that speech in our Constitution did not contemplate campaign speech, PACs, all of those sorts of things? And to the extent that you do, or to the extent that we do, is a compelled disclosure, compelled speech, such that provision would be activated anyway? And I would refer you to my concurring opinion in Brush versus Nib that talked about that.
Sorry, I haven't read that concurring opinion, so I'm not
I don't blame you.
Well, I don't think they had IEs in 1912, but they had ballot initiatives. And this act sweeps in donations to nonprofits and organizations on ballot initiatives. So clearly that wasn't permitted. There was a strong protection for anonymous speech at the time. That's how the women's suffrage proposition got passed in Arizona. All of those contributions, or many of them, were anonymous. Without that, who knows what would have happened, the very type of retaliation that we're talking about. So, you know, the concept of that, then at the same time, Your Honor, you have the Speak Freely Clause, which was passed, and also the Private Affairs Doctrine. So there were strong guardrails on this disclosure in terms of what you're talking about in Article 7, Section 17, and all those different provisions. There was a balance between the two. And when you look at what came out in Article 7, Section 17, it applied to candidates and campaign committees. There was a Proposition 70 that was proposed that was much broader. It covered all disclosures of any kind to an election, and it was a disclosure of everybody's name, and the convention rejected that. It wasn't passed. That's as clear evidence as I can show you that there were certainly limits to disclosure. In terms of compelled disclosure, when you make somebody produce for publication their name, their address, their occupation, and their employer, when they don't want to disclose that, of course that's compelled speech and compelled disclosure. It's limiting your ability to contribute to these nonprofits, but at the same time making you speak by making you disclose. Did I answer your question?
You did, thank you.
Counselor?
I'm going to follow up on that. Is there any, it strikes me, especially you go into the privacy clause as well, you have claims under that, and we've said in Mixton that it's, is this a reasonable privacy interest that society is prepared to view as private? A donation made to a nonprofit seems that it comes with no strings attached when you make that donation. Is there anything that is sacrosanct about that? There any kind of guarantee or assurance that that nonprofit won't simply post a list of its donors, for example? In other words, I'm getting to what kind of reasonable expectation is there that this will be something that's privately kept?
Well, in Mixton is completely different. In Mixton, it was an IP address. That's like an address on an envelope. So there was no expectation of privacy in
But
Mixton.
it's the only thing we really have under privacy.
Well, so Mixton also recognized that there was a sphere for anonymity and private affairs, just not in that context, and certainly not for, mailing around child pornography, which is a felony. Of course these donors have expectation of privacy. That's in the record, that all of these donors expected their names to be kept confidential, and all of these organizations assured them that their names would not be disclosed.
Subjectively, yes. I guess what I'm getting at is the standard is a reasonable one, which is an objective test.
Okay.
And so it strikes me as a little bit different is that what we're looking at, that especially on this facial challenge, is there a reasonable expectation of privacy that a donation made to a nonprofit for elections in particular here will be private information?
Well, it seems
in every case.
It seems hard to me to think that if bank records, there's a reasonable expectation of privacy. When you turn over your financial information to a nonprofit, and where you live and where you work and all that information, with the expectation that it won't be disclosed to the government, of course. I mean, it's the government action that's at issue. The government is taking this information and publishing it.
But wouldn't we, with respect to the reasonable expectation of privacy, Mixton involved customers of internet service providers who contractually waived the right to retain the confidentiality of their subscriber information, and in fact authorized those very companies who they entrusted that information to monetize their private information. Here, wouldn't we look to see whether the organization, the nonprofit, has made some assurance or there's some understanding as a condition of the donation that that donor information is going to be preserved? If we're looking at the reasonableness of it, isn't that the question?
Yes, and that's in the record, Your Honor. All of them were assured of that.
Mr. Gould, I tried to jump in here earlier, but it's tough with this crew. I want to get back to the
Is it just me, Your Honor, or is it the crew? I don't.
No. The as-applied challenge, you started out with that, and Citizens United says a disclosure law may be unconstitutional as applied against a party if the party pleads a reasonable possibility that disclosure of its contributors' names will subject them to threats, harassments, reprisals from either government officials or private parties, and that's Citizens United. In 16973F, they opt out what the statute, part of the act says that it has to be a serious risk of physical harm. It seems like the statute has narrowed the cover or the protection from U.S. Supreme Court precedent. Am I reading that correctly, or am I wrong here? Because I just want to see. Obviously, I think that the trial court and the Court of Appeals applied the statute here, but maybe neglected our federal case law.
Well, the respondents concede that, and the Court of Appeals used the correct standard in terms of reasonable probability. Clearly, the statute as written is unconstitutional, and it isn't what the standard is that was set. So There's no way that that limitation can stand. It removes social ostracism, it removes economic harm, it limits it to family members, it excludes friends. It's a total arbitrary line that's drawn that it bears no basis in the Constitution or Supreme Court precedent.
Counsel, let me ask you one question about that provision, though, because as I read 973F, it references the identity of original source that is otherwise protected from disclosure by law or a court order, or that demonstrates the satisfaction of the Commission that there is a reasonable probability that public knowledge would subject them to serious risk of physical harm. Is that limitation to serious risk of physical harm limited to demonstrating the satisfaction of the Commission, or do you read that as also being the only basis on which a court order could be issued?
Probably the latter. I think the problem with the Commission's decision is that any private individual can challenge that. If the individual makes a complaint, even if the Commission says we're going to protect that, a private individual can go to Superior Court and say, no, that's not what the statute requires. This is traceable. And so there's really no protection under subsection F of that private cause of action.
And real quick, I see the time's going down. But we've talked about everything so far except what the appropriate standard of review should be. Mm-hmm. And in the court's order granting review, we admonished the parties to discuss whether or not we should even use tiers of scrutiny. Mm-hmm. And we haven't talked about that at all yet. So should we use tiers of scrutiny, or should we instead, and this is why I mentioned Article 4, Part 1, Section 1 earlier, when it comes to regulating a provision in the Constitution that's otherwise provided for, and that's why I listed all those other sections, because we have various interacting sections of the Constitution. Wouldn't we use the standard that we have in Stanwitz v. Reagan, or Reagan v. Stanwitz, that the regulation of a constitutional provision can't unreasonably hinder the exercise of that provision if there's otherwise authority for the legislative power to act in that area?
Madam Chief Justice, what would you like me to do?
You may answer the question, and then that's it.
All right. I'm not sure if I can cover 250 years of constitutional history on these scrutiny standards that quickly.
Well,
but
forget
let me
about
say
those.
this. Okay.
Let me make my question very direct. Since we don't have tiers of scrutiny adopted as a concrete basis for interpreting our free to speak provision of our Constitution, and we're dealing in the context of issue advocacy, ballot propositions, the right to enact law through the initiative, why can't we use an unreasonably hinder standard as discussed in Stanwitz to determine this issue?
Well, you could. I think the closest standard would be strict scrutiny, because these are content-based restrictions. It's media spending, it's political spending.
So you're arguing that we're bound by federal jurisprudence to determine this issue. So again, if we don't use tiers of scrutiny, why can't we use the Stanwitz standard?
Well, you can, but I would argue that the most analogous would be strict scrutiny. But there are other standards in terms of the only limitation on the Speak Freely Clause is that there not be an abuse of that speech. That could be its own standard. Unprotected speech would be an abuse. Unfair pretrial publicity would be an abuse. You could certainly categorize this into what is speech that is abusive and speech that is not. That's actual textual construction of the state constitution. Thank you, Your Honor.
Thank you, Mr. Gould. Okay. Mr. Frazier.
Good morning, Your Honors. May it please the Court. My name is Eric Frazier. I represent the Arizona Citizens Clean Elections Commission. I will be dividing time with Alex Samuels from the Attorney General's office. Our plan was a 15-5 split, but now that you've given us some more time, we'll play it by ear a little bit. I want to start with the facial challenge, because I think that's where we ended a little bit with Mr. Gould. This case is about whether the Arizona Constitution prohibits its citizens from requiring meaningful disclosure so that they can know which big spenders are trying to influence their elections. Now, I think what's important to remember is that nobody disputes that the state can require disclosures of funding sources in campaigns in some circumstances. No one disputes that. And so the plaintiff's focus on anonymity and doxing and the like are red herrings, because somebody is going to be disclosed. That's what our Constitution requires. So the only question is, who gets to be disclosed. So the plaintiff's arguments prove too much because they don't make allowance for any disclosure at all. That can't be the rule in Arizona because our founders disagreed with that position. They chose sunlight over darkness. They required disclosures and campaign finance contributions. They completely prohibited corporate contributions aimed at influencing any election. That includes initiatives and referendums.
Counsel, do you have any authority to support that last point, that the initial disclosure provisions in the Constitution necessarily included initiatives?
So Article 14, the Article 14, Section 18, which is not about disclosure, but it's about the corporate contribution ban, says it shall be unlawful for any corporation, and so on, to make any contribution of money or anything of value for the purpose of influencing any election or official action. So our founders were deeply concerned about the role of money in elections, including initiative elections. And so the plaintiff's arguments about the harms of disclosing people, they just prove too much because someone is going to be disclosed. And we have a constitution that is very different from our federal constitution on this point. All of the arrows point in one direction here, in favor of disclosure, in favor of providing voters with information. And we had founders who were deeply, deeply concerned about the role of money in politics.
So how do, and I'm sorry for interrupting you, but I'm trying to get my questions in before.
Yes.
So how do we deal with the fact that there was anonymous speech with respect to initiatives at the founding or shortly thereafter, particularly with women's suffrage?
So I think a couple of things, Your Honor. First of all, again, we have at least some restrictions on the form that anonymous speech can take. If you are a corporation donating money, both of these plaintiffs, or the two named plaintiffs are corporations in this case. If you have corporations spending money, even on an initiative, that falls within the constitutional provision that I just read to you. And we have, again, laws around the time of the founding that require disclosure. What we have to look at here is whether there is an informational interest, whether there is a legitimate government interest in disclosure of the funding sources of money that ends up getting used on initiatives. So I think what you're getting at is that Article 7, Section 16 may not have applied directly to initiatives. But Article 7, Section 16, which requires disclosure, does not set a ceiling. It sets a floor. So our founders...
How does it do that? It tells the first legislature to do something.
Yes.
Isn't that done, apart from perhaps informing us about what the framers thought? Does it have any continuing vitality? It doesn't seem like an open-ended authorization, but rather a very limited directive.
Right, and so we're not contending that Prop 211 falls within the scope of Article 7, Section 16. So I want to be very clear about how it's relevant. It's relevant because it shows that campaign finance disclosure was a core value of our founders, which makes our Constitution different from the federal Constitution. The federal Constitution, you have the First Amendment on one hand, you have no textual provisions about disclosure on the other hand, and yet campaign finance disclosure laws generally survive scrutiny.
It tells us that the founders were deeply interested and concerned about disclosure of contributions to candidates and their committees.
Yes.
And as I understand the record, they rejected Proposition 70, which had broader language that would have clearly swept in funding related to initiatives.
So I think the Proposition 70 issue is a little bit of a red herring because we look at things like that when we're trying to determine whether a particular government action is authorized by or prohibited by that provision of the Constitution. We're not doing that here because, again, we're not contending that Prop 211 falls within Article 7, Section 16 as adopted. But the fact that the founders didn't enact that detailed provision doesn't say anything about whether the legislature or the people could do it later. Because what you see there is instead of spelling out the details and the minutiae in the Constitution, the founders said, let's leave it for the legislature. And we see that in several other places in the Constitution, where and this surprised me when I looked into it, how many places the Constitution requires the first legislature to do something.
But it definitively tells us that the founders did not believe that requiring disclosure of donations to political candidates and their committees, that didn't in any way implicate Article 2, Section 6 or Section 8. Why doesn't, given Justice Bullock's point that it was a very definitive and limited directive, why doesn't that inform in any way the relationship between what the founders found with respect to disclosures in Article 7, Section 12, and the broad rights under Article 2, Section 6 and 8?
So I think what you're getting at, Your Honor, is similar to the natural implication of the plaintiff's position, which is that I think in their view that there are only two types of potential disclosure laws. One type is laws that are constitutionally mandated, and the other type is everything else is forbidden, that there is no latitude for the legislature or the people to require other types of disclosure. But I think nothing in Article 7, Section 16 suggests that it's a limitation. It's a requirement. It's a mandate to the legislature. It's not a limitation on the people's power or the legislature's power. And as to Justice Bullock's question to Mr. Gould, anonymous donations were not speech at the time of the founding. Speaking in 1910, 1912 meant making sounds with your voice. It doesn't mean anonymous donations of money. And just, I think you asked the follow-up question, Justice Bullock. I figured you might be getting there. Disclosure at the end of the result of this process is not compelled speech within the meaning of Article 2, Section 6, because again, the Constitution requires disclosure. And there are lots of disclosure laws on the books today that are not being challenged of all types. And no one is contending that mere disclosure is unconstitutional. What they're contending is that this particular disclosure, disclosing the original source, is unconstitutional. But disclosure of a donor does not fall within the meaning of Article 2, Section 6. The donor is not speaking, the donor is not writing, the donor is not publishing. Justice Montgomery, you asked about the tiers of scrutiny, and I want to be clear on this too. No one is contending that you have to apply the federal tiers of scrutiny, but the free speech right is not absolute. This court has never interpreted it to be absolute. It can't be interpreted to be absolute because then you could solicit murder, you could price fix, you could do all these things. And you could even do a lot of things that aren't generally considered to be abuses of that right. So I'd like to talk about the abuse of the right section. We have all sorts of requirements and laws and regulations in Arizona. Things like that people would not view as being prohibited by Article 2, Section 6, and also are not abuses of the speech right. If you sell a house that has a swimming pool, you have to disclose you have to make a disclosure about pool fences and enclosures. You have to make disclosures about lead-based paint. Companies have to disclose who their directors and officers are, and that's publicly available. If you're a physician, you have to have a publicly available address with the medical department. Yes?
Counsel, let me ask you a question that related to the line of reasoning that you're presenting. That's all well and good because none of those disclosures necessarily could result in someone being threatened or intimidated or facing reprisals because they included in a MLS listing that they don't have a pool fence. But in this particular instance, and again, we're at the 12B6 stage. You've read the same declarations and affidavits we have. We take this as true then. There are people who have engaged in speech and they have been threatened and they have a reasonable fear of being threatened. And it's not lost on us what happened yesterday. So there is a very real threat to people who speak on certain matters, whether or not they are going to face more than just physical harm too. And the record and the arguments of the parties identify other circumstances too. So when we think about the right to freely speak, aside from the abuse of that right, the otherwise exercise of the right, why wouldn't we look at whether or not these mandated disclosures could chill that speech? And doesn't, again, 16-973F seem to acknowledge that there are going to be circumstances where that could occur? And then if you would agree with me up to that point, then is being able to go to a court sufficient?
There's a lot to unpack. I'll try to start at the beginning.
Thank you, and that's
okay.
where we're at too, trying to unpack.
Right, so I'll start at the beginning, which is, yes, courts can consider the effects that these laws have. That's why we do things like, something like exacting scrutiny. Again, you don't have to apply exacting scrutiny itself, but at the end of the day, because the speech right is not absolute, you have to have some kind of tool for lower courts to be able to distinguish between laws that do violate Article 2, Section 6 and those that don't. And so considering those burdens, considering potential chilling or deterrent effects is all part of the constitutional analysis. But the plaintiffs haven't offered you anything other than either an absolute right, which is demonstrably false, or strict scrutiny, which is just a more serious federal standard that seems really out of place in Arizona when we have our constitutional founders so suspicious of money in elections. As to the as-applied challenge, Justice Timmer's point, I think, is a very good one, that what the plaintiffs are asking for is the right to opt out of a generally applicable law for every topic, for every election, for everything. That's the relief that they're seeking. They did not come into court and ask for an injunction about a particular donation, about a particular donor, about a particular election, about a particular disclosure. They're asking for a right to opt out of a generally applicable law. The standard for that is very, very high. You have to show that there is a reasonable probability that these threats and violence and so on will result against the donor. And so it's true that you don't have to necessarily show threats against the donors in particular, but they do have to show that the evidence that they have shows that their donors have a reasonable probability of these types of threats.
Let me ask you a follow-up question on that then. Is it sufficient for 973F to provide a means for being protected from disclosure in light of the fact that if there's a ballot initiative that's on the horizon, it's a year out, it's being circulated, does CAP or FEC have to go to court now to argue that we want to participate in that, and so any monies that we may raise are going to fall within the category of concerns that we've been talking about? Do they have to preemptively go into court and say, we want to participate in that, but before we're able to raise any money or provide notice to anybody, we have to initiate an action?
So they don't have to even go into court. They can go to the commission through a regulatory process.
And I do have a concern about that too, because we have authority for an administrative agency to issue a ruling involving a constitutional right.
So I want to be clear, subsection F is not meant to completely encompass the as-applied challenge. And statutes don't generally have to incorporate every limitation that the Constitution has in terms of an as-applied challenge. And so the statute did not need to have any provision like subsection F. And it is, again, is not intended to capture the full as-applied challenge.
If they narrowed their as-applied challenge to initiatives that dealt with what their organization advocates for, pro-life, pro-marriage, those kinds of topics, and puts it a little narrower directly to what they do and advocate for, would you have the same argument against their as-applied challenge? Because I do take Justice Montgomery's point from his question that is it not chilling in itself to have to anticipate years, possibly in advance, to get donations for what your organization stands for?
I take the point, Your Honor, but I think they would still need to show that there's a substantial or reasonable probability that their donors would face those kinds of things. We've had disclosure in Arizona for more than a century. City of Phoenix has had disclosure of original source contributions for many years. We just went through an election cycle where Prop 211 was in effect. We don't have evidence here or anywhere else that campaign finance disclosures result in these kinds of threats. We have lots of terrible things that are happening in the country, generally directed at the heads of organizations and so on. But these groups have their boards of directors who are public. They have their PAC donors who are public. We don't have any kinds of allegations that any of these people are being threatened because of their association with the entities.
What do we take, for example, Tesla owners? I mean, this is the milieu we're in now. People who own a product that they purchased, often well before the owner of the company became overtly and enthusiastically involved in supporting a political candidate. There are scores of well-publicized violent attacks on those people and their property for their perceived support of an individual where the perception is irrational in most instances and wrong. Why can't we consider that in this political climate?
Well, one reason, Your Honor, is that our Constitution requires disclosure of donations. And I know it doesn't require the same disclosure as what we have in Prop 211, but when we're looking at an as-applied challenge under the Arizona Constitution, we have to consider that our founders looked at the risks and benefits of disclosure versus allowing people to remain anonymous, and they chose disclosure. They chose sunlight over darkness.
But they also chose to protect speech and to protect private affairs. And I want to ask you about the structure of those two provisions, because there's a similarity between them that I note. It seems to me, with regard to protecting donor privacy, especially in a very controversial, on a very controversial issue, but generally speaking, as Justice Lopez said, even with the car that you buy, what this proposition does is to basically put the speaker in a please may I situation. And neither Article 6 nor Article 8 are structured that way. Both of them are structured, Section 6 is being held responsible for the abuse of that right, presuming that the speech can occur and punishing violations of that. Same thing with private affairs. The presumption is that the private affair is protected except with authority of law, which in this context would seem to me record keeping, investigations, perhaps disclosures of active players who have designated their funds for use in politics rather than are seeking or not doing so. Structurally, don't those two provisions suggest that the presumption ought to be in favor of private affairs, in favor of speech, subject to limitations for wrongdoers?
The answer is no, Your Honor, because at the time of the founding, I don't think anyone thought that money, anonymous money, used in campaigns was speech within the meaning of Article 2, Section 6, or was a private affair within the meaning of Article 2, Section 8, because those same arguments would apply to disclosure of direct donors, which we have under Arizona law, we have under federal law. Much of it is constitutionally required. And yet, no one is challenging direct donors. This is only about the traceback. And so that's the problem, is that the plaintiff's arguments prove too much. If disclosure of indirect donors is a private affair, then so is disclosure of direct donors, because it's the same things at stake. I have a quick procedural point, Your Honor, which is I don't think the private affairs clause is appropriately in this case. The plaintiffs did not petition for review on that issue. It was raised below. They did not include it in their petition for review. It sprung back to life in the supplemental brief, which I don't think is appropriate. But on the merits of it, since I'm not getting many head nods on that point, on the merits of it, it just is not a sweeping privacy protection. This is money that is used in public elections. It is used in campaigns. That is the very quintessential aspect of what is public. And the plaintiffs say that you should evaluate candidates on their merits, which again, I think is a really nice thing to say, and in some ways I agree with that. But that is not what our founders believed. Our founders wanted to know the source of the money. They were so distrustful that they banned corporate contributions of any type. This is a pro-disclosure constitution, and if we want to take originalism of the Arizona Constitution seriously, we have to grapple with those provisions. The required disclosure, the corporate ban, these are all the arrows in our Constitution point in favor of the voters. This is a pro-voter Constitution.
Counsel, one last, hopefully a quick question for you, though. In the context of Article 4, Part 1, Section 1, because when it comes to issue advocacy, we're also talking about the people exercising their right to enact law through the initiative. If these disclosures also inhibit someone's willingness or ability to fund an initiative or to advocate on behalf of a ballot proposition, don't we have to take that into account? Isn't that another context in which to see how the Voters' Right to Know Act is affecting the right to freely speak?
I don't think so, Your Honor. I don't think Article 4 gives people a right to raise money for these things.
Well, how are they going to do it otherwise?
Well,
You got to get signatures.
And so again, you look back to Article 14, Section 18, where corporations are completely prohibited from spending money, even for the purpose of influencing any election or official action. That is a really broad provision. And so if the founders thought you could completely ban corporate contributions and corporate expenditures, then surely the people or the legislature could require disclosure. Disclosure that just goes a little bit farther than what the founders said was required, the absolute floor in Article 7, Section 16. I'd like to let Mr. Sam...
Sorry.
Okay, sure.
Sorry. I'll do what I did in the previous case, which is you can answer it or he can answer it.
Okay.
I wanted to get a bit granular and ask you about Section 16971 2A6,
Sorry, would you mind giving me just
yeah,
16,
and I will
972.
give you the relevant language because I don't expect you to have all this memorized. 16971 2A6, which requires disclosure of, quote, partisan campaign activity, end quote, that supports the, quote, electoral prospects of an identified political party. And I have no idea what that means, so I'm hoping that one of you can illuminate me as to who is being disclosed there, what the types of activities are.
So I think when you look at subsection 6, and I'm sure you know this, but no party has raised this, but if you look at this, it requires a couple things. Number one, it requires a public communication. So I want to be clear about that. I know this is not answering your question directly, but it's important to remember this is not just about casual speech or Facebook posts or Twitter posts. This is about paid media, $50,000 or more, and it requires an identified political party. So that means, Republicans or Democrats or what have you. And so I think you're focused on the word electoral prospects. I think that's things like, vote for Republicans in the next election. That's, I think, the kind of thing that would be included there. I want to make sure I don't use up all of Mr. Samuels' time, so I'd be happy to answer any more questions for me. Otherwise, I'll turn it over to him. We ask that you affirm. Thank you very much. And thank you for giving us a little bit more time.
I don't know why he's rushing. 6 minutes and 15 seconds is luxurious compared to what I expected. Good morning, Your Honors, and may it please the Court. Alexander Samuels on behalf of the Attorney General. Justice Bullock, your question, I think, sort of ties into where I wanted to start, which is try to make sure we don't lose the forest for the trees here. There are a lot of trees here. We can get into the nitty-gritty of what happens in subsection 2A6. And a lot of those questions really matter in this case, but so does the big picture. And so I think I want to make a couple points in that regard. One is to point out how broad the request is from the plaintiffs. Really, at bottom, they ask this court to go further than any court has ever gone in this context. They ask this court to apply strict scrutiny or something like it in the context of their facial challenge, when there's really no authority for that. The federal courts have declined to do that over and over again, and they have not pointed to state courts that have gone nearly as far. And I think that's exactly the opposite of what this court should be doing when our Constitution is one of only a handful in the whole country that constitutionalizes campaign disclosure as a value. I also want to... Let me
check your premise on that. What about the 10th Circuit in Wyoming gun owners? They did not per se apply strict scrutiny, but they observed that Bonta had adopted a narrow tailoring aspect. And frankly, I don't see the difference between that, and there's not much daylight between that and strict scrutiny, and they did, invalidate some similar provisions in that case.
Yeah, Chief Justice Roberts' opinion for the court in Bonta says there is a difference. And this is addressed very clearly in there, where he says, let's not confuse things. Least restrictive means does not mean narrow tailoring. There's a scale of what kind of tailoring is required. Strict scrutiny is at a further end of the scale, I think, is the best way to describe it. But I think, talking about the federal precedent there, think about this case in relation to Citizens United as well, in terms of how far they're asking this court to go. All the attention on Citizens United as to its first holding, limits on independent expenditures. There's a second holding, though, and it's really important in this case. By a vote of 8-1, they simultaneously upheld disclosure. And those two things were intertwined. Part of the reason they struck down the limits was because they said disclosure was a sufficient alternative and was nonetheless constitutional. And so really, at bottom here, I think plaintiffs have to say that Citizens United is not enough for them, that they want this court to go further than that. And I know there are more granular arguments that are more, maybe you could have something like the Citizens United test and still Prop 211 goes a little too far. But if you look at their arguments, especially in the most recent briefing, that is not really what they're saying. And I think a lot of their arguments really ignore a lot of the other Arizona constitutional provisions that have been brought up here. I think in particular, I want to talk about Article 7, Section 16, and point out how in trying to get around Article 7, Section 16, or try to deal with it, they have basically fundamentally misrepresented what it says. And I want to back up that assertion with a couple citations. Take a look at page 6 of their supplemental brief. They say Section 16 tells the legislature that it can enact a campaign finance disclosure law. Can is their word, and they emphasize it. But you'll notice there's no quotes around it because that's not what Section 16 says. Section 16 says shall. They characterize Section 16 in the response to the scholars' amicus as a restriction. But there's no textual evidence that it's a restriction. There's clear textual evidence. It's a mandate. And in that same brief, at page 7, they say that Section 16 is the sole exception to the speech right in this context. And as Mr. Frazier pointed out, that is a remarkably broad proposition. What that truly means is that the legislature and the people have no discretion whatsoever. That cannot be the case. I mean, the scholars' brief points out that in the debate about this, the discussion about whether to include all elections or only candidate elections was not, we're really afraid of interfering with speech rights, or, we really are afraid of initiatives. The discussion was, this is a constitution, and so we're merely setting a baseline, and we'll leave the legislature to do the rest. There's even a quote that, I'm paraphrasing, but is right along those lines.
Well, it strikes me, Mr. Samuels, certainly there's a lot of regulation around elections and around the integrity of elections. Among other things, of course, people have to get, people and initiatives have to sign sheets. We all sign the, I don't, but other people sign the sheets. I don't want to be conflicted off. So you sign the sheets to support, the person or the initiative or the referendum that you're in favor of. Those things are subject to disclosure and scrutinization and lawsuits and everything else. So you can see the names of the people and you can see all, where they live and the whole thing. Certainly, I don't think anybody says that's not allowed, even though you could say, well, this is speech. That's speech, and you're compelling disclosure by having that, and people can be harassed, et cetera, et cetera. But that's certainly necessary to make sure that the integrity of the election. Where is the dividing line here? I guess that's what I'm at least searching for in implying, as you advocate for exacting scrutiny. How do we arrive at, well, that's okay, even though it certainly subjects those people to ridicule, harassment, et cetera, but it's not, where do we look at then with disclosure of campaign financing?
Yeah, I think on the ridicule harassment front, I think you really have to look. You don't have to get as granular. These donors don't need to say, look at this threat I got. But I think it's relevant in this case. They can't point to a single instance against any donor anywhere. They're pointing to instances where the party headquarters or high-profile officials are affected. So I think that mismatch matters here. And I think the exacting scrutiny test is helpful on this front, even if you apply something that sort of resembles it and is not its twin. I think something at least like its sibling makes a lot of sense here. You look at the government interest and is it sufficiently important? I don't think that's really seriously in dispute here. You look at whether the law or regulation substantially furthers that interest, and I think that's not, maybe it's a little bit in dispute here, but I don't think by much. And I think really the fight here, if you're applying exacting scrutiny, is on the narrow tailoring front.
And on that front, I know you're out of time, but everybody else has gone over. So.
And you're the chief.
I am the chief. It's good to be the chief. And I'm going to give Mr. Gould. I'm going to give you at least a couple minutes to rebut if you'd like. You don't have to. On the narrow tailoring, one thing, could you please just quickly address what I call the downstream donors, the one who contribute $2,500 plus $1, I guess, to someone who then packages that up and donates it to, say, CAP. Certainly that donor needs to be, the big donor of the $50,000 or whatever, needs to be given the opt-out provision. What about that downstream donor?
Sure. A couple things there. First of all, no one who donates $2,500 or $2,501 gets publicly disclosed. The threshold is $5,001.
Okay,
$2,500 is like a housekeeping measure to try to avoid structuring of transactions and detect that. That would not be publicly disclosed.
Isn't it in the statutes that if you get more than $2,500 as part of the bundle of the $5,000, I think, that it has to be disclosed?
The only way you'd be publicly disclosed if you give a total of over $5,000, and any one particular donor gave more than $5,000. The idea is if you donate $2,700 here, $2,700 there, $2,700 there, that you don't want to avoid disclosure by having people be able to structure transactions.
So do those people, the 25, the 27, all those folks, do they get the opt-out?
They do not. So the opt-out goes to the direct donor. It does not go to every donor downstream. I think one point I want to make as it relates to the narrow tailoring is that some of the arguments here can get a little bit heads I win, tails you lose. So, for example, in the No on E case, some of the judges dissenting from denial of rehearing in that case, who wanted to strike down, I think, the law there, said, well, this law only goes back 2 levels. It doesn't go all the way back like Prop 211. So it's under-inclusive. Here we go all the way back, and so we have plaintiffs who show up and say it's over-inclusive. I think it is difficult to craft a perfect law, but that is not what's required. And in terms of the opt-out for the indirect donors, I think we have to think about how this is going to play out in practice. First of all, direct donors are going to get an explicit opt-out. And while there is a 21-day period for that, I think it's very rarely going to be used because they can opt out and get the notice right at the time of donation, even before the donation. And as to the indirect donors, I mean, these are large dollar donors. And I think some of the hypotheticals about the church in the Ninth Circuit argument in the related case, the hypothetical was a nun gives to a pro-gun rights organization, that gives to a pro-choice organization, that then spends the money. I think that if that is an actual application of this law, it's certainly not a substantial number of applications, which is what they need to do for their facial challenge. I think what we have here is large-scale donors, and the odds that these folks are not going to be talking to each other, the odds that an organization is going to spend a donor's money against their wishes, I think are very unlikely. And the indirect donors can always restrict their donations. Independent of, they don't need Prop 211 to do that. They can give money to say, please don't use this for campaign media spending. Please use it for whatever other purpose you want.
Are $5,000 donors really big money donors that are corrupting our politics when someone donates $5,000 over the course of an election cycle? Is that? I mean, I know that's not before us, but if Prop 211 is sold to get behind big money, is disclosing the identities and the home addresses of people who donate $5,001 in an election cycle or for advocacy through a nonprofit really getting at the heart of corrupting money in politics? Is that really an interest that balances against what I have serious concerns about the risk to their safety?
Well, it seems like a lot of money to me, but let's set aside my own views for a second. I think it's a substantial expenditure threshold. It's one of the highest. All the cases that we've cited, both sides have cited in the briefs, have all these other laws. Thresholds are often $1,000. Sometimes they're in the hundreds. $5,000 is actually quite high in comparison. The other thing is, let's say you do have concerns about the $6,000 donor, but not about the $500,000 donor. What you may have there is an as-applied challenge, I guess, by the smaller big donors, I might call them. But again, I want to get back to their request here, and their facial challenge is much, much broader and asks for really broad relief. I think, you know, you might be able to leave the door open for as-applied challenges if you had concerns like that. But that's very different than striking down the whole law.
And a very quick mechanical question. I apologize. I probably somehow overlooked this, but when you're searching, when an organization is searching for original sources and has a lot of money and only spends a little bit on a particular political point, how do they do that?
Yeah, it's a good question. So there is discretion given to the donor in this regard in several ways. So this is actually a good contrast to the 10th Circuit case you cited. There, Wyoming said, our law requires that once you spend up above the threshold, there was $1,000 rather than $50,000, then you have to disclose every donor from the whole campaign cycle. If you get $1 million and you spend $2,000, you got to disclose $1 million worth of donors. That is not what Prop 211 says. In 972, Prop 211 allows the organization to designate only the money that they've used for campaign media spending. And it gives them the choice in that regard. It does not require them to use some particular accounting method or, much more importantly, disclose all their donors. If they only spend if they spend, say, $100,000 on campaign media spending and they get $5 million in contributions, they can pick which $100,000 they have used for campaign media spending and only report based on that amount, which again is another way in which this law is much more narrowly tailored than a lot of the other ones that cases have considered.
Thank you, Mr. Samuels.
Thank you.
Okay, Mr. Gould, if you'd like, you could maybe rebut for a couple minutes. 2 minutes. I know you can do it. You can do 2 minutes.
All right.
Minutes, please.
Let me address these. All right, let me try to address these quickly. First of all, original donors of $2,500 or more are disclosed. If you look at 16973, Section A7, the intermediary has to disclose, and everything the intermediary discloses is disclosed by the Secretary of State under Section A. The original sources, including the date, amount, and source of the original source. So the intermediary has to disclose who the source was, and that report gets disclosed by the Secretary of State, so they are disclosed.
Is it at their discretion to decide who, or is it like back to accounting, like a FIFO or a LIFO kind of thing?
Well, they have to. It's mandatory. They have to report all those original sources above 2,500. The intermediary does to the covered person, and the covered person has to make those disclosures under the statute. Second of all, the informational interest here, I think you have to think about this. What exactly is the average donor supposed to do with a list of 100 names? What do they know about those people? Activists know what to do with it, but the average person doesn't. So it's a very weak informational interest to just throw all these names out there, especially for organizations like CAP and Free Enterprise Club. All you have to do is click on their website. You know exactly what they stand for. So there's no obscure organization that they're standing behind. Second of all, it is absurd to say that money isn't speech. Of course, money is speech. That's how we express ourselves. That's how people engage in speech, particularly in elections. A couple of quick other points. The reason why we allow candidate disclosures or donations to candidates is because of the anti-corruption interest. We are concerned about a quid pro quo. And Buckley, Citizens United, and Bonta say there is no anti-corruption interest with IEs because they're independent of the candidate. So we've drawn the line on the anti-corruption interest. It's so strong that we require those disclosures. That's the balance that we've reached in this country. I would also say this. There is no statute that requires disclosure of contributions to nonprofits. They're not political committees. And last, I'll simply say this. When you look at Article 7, Section 16, you have to balance that with the speak freely and the private affairs. That's the compromise that the founders reached in our Constitution. Thank you.
Chief, may I ask one final question?
I'm sorry.
No. The opt-out notifications, I'm trying to make sure if I understand the statute correctly. So the opt-out notices go out, and they have to indicate that they're giving that the donor is given an opportunity to opt out of having the funds used for campaign media spending. But is there any basis in the statute or requirement in the statute that they be told precisely what the funds will be used on, what candidate, what message, or anything? Or is it just a notice, we hereby notify you that you are given the opportunity to opt out of these funds being used for campaign media spending?
That's right, Your Honor. There's no earmarking requirement either. So they're not notified of how it's going to be spent. And again, the problem is the definition of campaign media spending is so broad, especially under Section A7. It sweeps up virtually anything that the organization does. There's so much overlap between issue advocacy and policy research and how that information makes it into campaign ads. There's really no assurance. So what you have in the record here is that the organizations are just not taking these donations because they can't guarantee, or not donations above $2,500 because they can't guarantee to their donors that that money won't be traced back and flow into campaign spending ads. So they've censored their speech. And they've censored their speech for political ads and for also issue advocacy as well.
Thank you. Thank you, Chief.
Thank you. Well, thank all counsel for your really excellent briefing and excellent argument here, all sides today, and all the amicus that weighed into this. We realize this is an extraordinarily important case and issues that will reverberate for many years to come. So we will take this under advisement. We will certainly give it all a due consideration and discussion among us. Until then, we will stand adjourned.